Good morning, all. And I've been trying to record this video, and I have hackers that are trying to stop my videos, cutting it off in mid-video. But I'm going to go ahead and make this video because this video is of significant importance. And my video today is about being autistic in the federal courts. And this is based on my lived autistic experience in my cases in the federal courts. And so the first thing to know is that autistic people have existed throughout human evolution. We didn't just become invented when Leo Kanner identified autism in 1943 to 44. Autistic people have existed since before modern humanity. And it's no longer that, in an Oliver Holmes, Buck v. Bell type 3 imbeciles are enough type mindset. If we find the one gene for autism, we can cure autism. And so then the neurotypical majority in the courts can have free and clear sailing, and there won't be any more autistic people anymore who need access to the courts and need to participate in the court systems, especially the federal courts. And so if you go on Google and you start querying in whether certain historical figures were autistic, such as some of the most important people in the legal profession, our founding fathers, and this is of importance to the Federalist Society. Thomas Jefferson, was he autistic? And you get articles saying he was autistic. Was James Madison autistic? Yes, you can Google in and get articles saying that James Madison was autistic. Was Benjamin Franklin autistic? Yes, you can get articles saying that Benjamin Franklin was autistic and that Albert Einstein was autistic. And there are many, many autistic people who have existed throughout our history in the United States. As Simon Baron Cohen says, autistic people tend to assortatively mate. And you tend to find autistic people arising out of parents who were mathematicians and engineers and involved in scientific thinking. So autism and autistic people have existed throughout evolutionary history. And there was a time when autistic people were lawyers and litigated and had access to our federal courts. And I would like to describe it this way. We all can remember the nomination hearings of our Honorable Chief Justice John Roberts Jr., where he talked about a judge's role as being an umpire. Well, I was personally present at about the 2007 Federal Bar Gala in Tampa, Florida, where the newly minted Associate Justice, Honorable Samuel Alito, gave a speech, and it was to elaborate on what Honorable Chief Justice John Roberts Jr. said about being an umpire, about a judge's role in being an umpire. And what Justice Alito said was very impactful, and it was very important. He talked about how there can be two equally valid players in the game, and an umpire's role is to call the balls and strikes. And sometimes there's a new group of players who comes along and they change the rules. And what that does is it starts excluding the older, equally valid players who played under the old rules. All of them are equally valid players in the game. And so we come to this flux in our history in the United States where eugenics was rampant and bar examiners started being formed and created to screen who could be a lawyer and culling them to the neurotypical type using things like Stanford Binet IQ tests and intelligence scales and all sorts of other things. And this was happening all over the United States. Well, the neurotypical majority also seized control of the federal courts in this country to deliberately exclude autistic people, autistic lawyers, autistic people, autistic litigants who want to bring cases. And it was called the creation of the Federal Rules of Civil Procedure in 1938. A law review article that talks about this. It talks about much needed reform, a time to shift away from arcane and clumsy pleading rules that trap the unwary and enrich the few who had encyclopedic knowledge of code pleading, and to institute a new vision of procedure employing much simplified pleading rules and speed was important. Now, who are the people with encyclopedic knowledge? Well, they are autistic savants. They are people we would have called Asperger's or Aspies. They are people on the autism spectrum. And people on the autism spectrum, some of the traits of being autistic are being very good with rule-based systems and with systematizing rule-based systems. Autistic people have an immutable trait of the way we communicate. And it's detail-oriented. It's fact-based, literal. It can be much longer than neurotypical people's writing. And certainly the interface, as I pointed out in my video of yesterday on implicit judicial bias against autistic people, the interface of the neurotypical and the autistic languages, which are different languages, would have caused the neurotypical majority in the federal courts to feel like autistic language was trapping the unwary. The unwary who? The unwary neurotypical people. So really, this whole overhaul of the federal rules, from fact pleading to notice pleading, was to make them shift from autistic language to neurotypical language being used in our federal court system. This is the autism discussion page on Facebook, Bill Nason. And he has a page that gives a lot of very state-of-the-art knowledge about autism. And he talks about autistic language being literal fact-based versus neurotypical language being inference-based. And it's because autistic people have a different brain. Neurotypical people see the big picture. They have strong central coherence globular brain, and autistic people have a brain that is more scaled toward Neanderthalization and is less globular and depends on stronger local connections at the expense of these long distance global globular connections. And so what happens is neurotypical people are dependent on inferring intended meaning from minimal details. By this inference language process, they look past concrete details and process the invisible relationships between the parts to read between the lines. And this allows them to read thoughts, feelings, perspective, and intention of others, which is known as theory of mind. That's the social language component in the neurotypical brain that the autistic brain lacks. And so, the inferring allows neurotypical people to share mental states and experiences with others and to make predictions about autistic people. The problem with that is autistic people use a very literal language. We do not infer hidden meanings in language. And so what happens is when autistic people and neurotypical people interact in language communication with each other, neurotypical people expect autistic people to linguistically relate at the neurotypical inferential level. And what that means is that autistic people are processing language literally about people are saying exactly what they mean and meaning what they say to the literal word, and there's nothing to be inferred. And what happens is that means that neurotypical people and autistic people are communicating through different languages on a different plane. It's not mutually intelligible. This is a February 1st post on the autism discussion page. Being autistic means having a very different nervous system from neurotypical people. And so autistic people tend to be bottom-up processors of raw sensory information. We don't filter our information through an executive functioning type integration process to make it meet what we expect or what our goals motivate us to want it to be before it reaches our consciousness the way neurotypical people do. And so our autistic common sense is really very rooted in how we use our words and categorize our world. Being autistic is very rooted in how we see, hear, smell, taste, and feel from our raw senses. And so this is a May 7th post on the autism discussion page. And so, year by year, after 1938, bar examiners and the neurotypical majority that are on these committees of bar examiners, and the neurotypical majority in the federal courts, and the almost 100% homogeneous neurotypical benches in the states have really tightened and ratcheted up the rules to exclude, eliminate, and segregate autistic people. In short, as I pointed out in my video of yesterday on the implicit judicial biases against autistic people, this is an unconscious negative reaction that occurs in about the first 20 seconds a neurotypical person experiences an autistic person, because we're odd and we're weird and we're out of sync. And so it happens. And there's really not much a neurotypical person can do about that unless they put in procedural safeguards in these cases, and unless they receive adequate, ample, and specific autism educational training so they can understand what's going on. Now, as we've gone through history in the United States, there's been this situation that most autistic people are not responsible for, don't have anything to do with it, but it is the phenomenon known as autism in school shootings. And the autistic school shooter has become a meme. And so this is a problem because of the court's reaction to this. All these articles and memes about every time there's a school shooter, like at Parkland, Florida, Adam Lanza at Sandy Hook. They're even going back to the Columbine school shootings. And every time it comes out that they're saying the school shooter was autistic. And this is a problem. These words that the school shooters suffered from some form of autism. Okay? Now, whether or not these school shooters were autistic, there are other people in society who do mass shootings who are neurotypical, but the focus that scares the neurotypical majority is they keep saying and doing memes about and passing stereotypes around and labels that school shooters suffer from some form of autism. And that is very damaging for the majority of the autistic population. Because first of all, it's using deficit-based language, like what we see in the Honorable U.S. Magistrate Gary R. Jones on the face of his orders in the case where he punished me for being autistic and my immutable autistic traits. He said, I suffer from autism. So you always see that the neurotypical population, the majority, is passing around its fear of autistic people because they're odd and they're weird and they suffers from autism. This is deficit-based language. And I can understand that if neurotypical people feel safe with cookie-cutter people who are all the same and they're all neurotypical and they all have neurotypical expectations and neurotypical social norms, they may feel very fearful around people who are odd and weird and different because they don't understand us. It doesn't make it right, though, to import this into our federal courts and create autistic school shooter memes and put this in to the access to the courts screening mechanisms for who gets their day in court. And this is what they've done. In 2007 and 2009, the United States Supreme Court decided two cases. One is called Bell Atlantic Court v. Twombly, and the other one is called Ashcroft v. Iqbal. And these cases changed the whole way that the federal courts are screening who has a valid and meritorious case and gets to go forward to get a remedy in their case. And they're screening it based on your immutable language traits. In other words, your First Amendment free speech. Now, there are law review articles about this, and in no way do I think that the Supreme Court of the United States, when it handed down these two cases, in no way do I think that the justices were targeting autistic people. They just made these cases and they set forth some new rules. But of course, these rules are again tightening this whole cascade of events that began with the 1938 creation of the federal rules. And maybe it's inadvertent. Maybe it wasn't really well thought about. But it's not what the United States Supreme Court did that is objectionable. It's what the 11th Circuit U.S. Court of Appeal did. But first, since these cases have been used against me in my own cases, firsthand, lived autistic experience, I want to talk about them. The Supreme Court created a standard of plausibility that required the pleading to consist of enough facts to raise a reasonable expectation that discovery will reveal evidence of what is alleged in the complaint. And in determining whether the complaint meets the standard of plausibility, the trial court should not decide the presumption of truthfulness based on conclusory allegations. Additionally, Twombly permits a court to use neurotypical inference-based language to consider inferences that favor the plaintiff as well as inferences that favor the defendant. And that in applying this plausibility standard, lower federal courts were instructed that a reviewing court must draw on its judicial experience and common sense. Now, what common sense would this be? Is this the raw sensory-based common sense of an autistic person? Or is this the neurotypical expectations and social norms common sense? Well, we're not really sure. And the Supreme Court did not say that lower federal courts have to use neurotypical common sense to evaluate autistic cases. And neither did the Supreme Court in Twombly say that plausibility meant only what is plausible to a neurotypical, which means that anything an autistic person has to say is almost always not plausible to a neurotypical. Why? Because they're not autistic, because they don't know what it's like to be autistic from the inside, because they don't experience being autistic and the lived experience of autism, and they don't even have specific judicial education in autism spectrum. So, but now remembering that I graduated from law school in May of 1990, so I was taught that it was okay to write lengthy complaints, to incorporate prior allegations into the complaint, into one count into another. Like you could make a basic facts of the complaint allegations, and then you make your counts, and you can incorporate the basic facts into each count by saying we were taught to do this in the first paragraph. And I hereby incorporate in paragraphs 1 through, say, 100 of the complaint as so fully set forth herein, and then you do your count. We were taught to do this. We are the old players where the umpire was calling the balls and the strikes. We were the equally valid players in the game. We were taught how to do this in law school, and I graduated in 1990, and I passed the California bar exam, the hardest bar exam in the nation, in July 1997. And then now the Supreme Court comes along later in 2007 and 2009, and it changes the rules of the game for the new players in the game. Okay, so then what happened? Well, the 11th Circuit Court of Appeal, and especially spearheaded by the hero of the implementation of Brown v. Board of Education within the 11th Circuit, Honorable Gerald Toflot, invented these rules called, and these are autistic shooter memes, because these rules flag and identify autistic language and the immutable autistic language speech traits of autistic people like me. And this is my lived experience of being autistic. So the 11th Circuit Court of Appeal started code speak because it's so afraid of autistic people in the courts because of all the fear-mongering and memes going around about all the school shooters are autistic. And they didn't want them in the courts for security reasons, for court security reasons. So 11th Circuit invented this rule called the shotgun pleading rule. So here it is. What is a shotgun pleading in the 11th Circuit? And it relates to Federal Rule of Civil Procedure 8 and 10. Okay. And even 20, as I've been told. Courts in the 11th Circuit are roundly, repeatedly, and consistently condemning shotgun pleadings. Okay? And this is an article that can be found here. When the Neurotypicals overhauled the Federal Rules of Civil Procedure, they got rid of the fact-based language used by autistic people, and they created what they called notice pleading. Notice pleading means the inference-based neurotypical language, the gist language by which neurotypical people communicate. And so Federal Rule of Civil Procedure 8A2 requires pleadings to contain a short and plain statement of the claim showing that the pleader is entitled to relief. This means that for an autistic person to get access to the courts in the 11th Circuit under their shotgun pleading rules that are identifying autistic people because they're using shotgun memes that is code speak relating to the fear of autistic school shooters coming to the courthouse because all autistic people are now feared, which is unfair. This is fundamentally unfair to most autistic people. Now, the rules require an autistic person to be indistinguishable from a neurotypical. In other words, we have to be able to use neurotypical inference-based language. And we have to be able to talk in gists and use recursive language and use iconic representations and make it go in and out at different resolutions so that we can use a short and plain statement at a simple resolution. And when the pleadings are going back and forth from the complaint to the answer between the neurotypical people, but never mind, we're autistic, we have to be able to take those notice pleading iconic representations and unpack them into the meaning of all their detail. Well, autistic people don't communicate that way. We can't do that. We have immutable traits that we are born with of autistic language, and it is different. So this is what the shotgun pleading rule is saying. It's saying we are forced as an autistic person to speak like a neurotypical, indistinguishable from a neurotypical, or our case will be thrown out. It will be dismissed involuntarily and with prejudice. We won't get access to the courts. We won't get a remedy. We will be excluded from the courts. And it gets worse in the 11th Circuit because you almost always get sanctioned under Rule 11, which I'll talk about later in this video. And so now, if you do a Google search for shotgun pleadings, you will come up with a lawyer that's talking about it, and he explains that, well, you know, the shotgun pleading rule thing is really largely concentrated in the 11th Circuit. A lot of the other circuits really don't do this that much. They really aren't as strict. They're really more lenient, and they're not as obsessed and fixated and strict and harsh with forcing someone to be indistinguishably neurotypical in the way the litigant communicates. So Now, if you query into Google shotgun pleading, the language that they're using is so biased and prejudicial, inflammatory and offensive to autistic people. Well, all I could do is show you some of it. Upholds dismissals and suggests sanctions for shotgun pleas. That's right. If you speak autistic and you are, say, not a level 1, but a level 2 or 3, and you cannot mask your autism, the 11th Circuit is not only suggesting you don't get access to the courts, you get thrown out and excluded, but you get sanctioned too for your immutable traits of your autistic language. Blatant and irreparable bias and prejudice. Certainly my lived autistic experience against me as an autistic person, because let's be clear, there is no proven connection between autism and the type of school violence. To say that these autistic shotgun pleading code speak for targeting autistic people and our immutable autistic language traits for exclusion from the court system within the 11th Circuit jurisdiction is prejudicial, well, just the whole thing taints any case that we're in to go against us. They want us to lose. They don't want autistic lawyers either. I mean, now, autistic people, you can query in on Google about what do autistic people write like, because it's not your oral spoken language that's getting you excluded from these courts, from access to these courts, and imposing punishment for the immutable traits you cannot change about your autistic language and how you speak. You could query in. You'll find all over the place that autistic people write too many details, too long, too much information, too much volume. I feel like this is a trap, and I'm already fighting myself in responding too long. Now, I've read a whole bunch of these, and all sorts of comments on Reddit and Quora and other places posted by autistic people. In addition to knowing what it's like myself through lived autistic experience. And, autistic people cannot write the short and plain statement. Autistic people's immutable language differences include writing too much detail. We process bottom up. We take all the details and we put it together like a jigsaw puzzle, and then we sequentially analyze it, and then we create categories out of it, what we see, and then, and only then, can we summarize it and put it into a neurotypical type package. That takes a tremendous amount of time. As the autism discussion page on Facebook says in some of its posts, autistic people have delayed information processing. And that is why, based on our immutable language characteristics and information processing characteristics, we take more time. So when these courts are saying justice without delay and at speed, on its face, they are discriminating against, and this is my lived autistic experience now, denying due process and equal protection to autistic people. And this has happened to me. So you can't have rules that facially say without delay and at speed and be inclusive of neurodiversity and autistic people in your court system. Now, there's been a lot of research that focuses on differences in structural complexity, organization, and perspective taking within the writings of autistic people. There's a lot of research. There's a lot of scientific research on autistic people have trouble with narratives, have trouble with story form, and certainly because autistic language is evolutionarily inheritable in autism, and we have immutable autistic language traits. We use bottom-up language processing from our raw senses. Because of this, we don't do the organization of our writing the way a neurotypical does, which is to make a short and concise, plain statement, a gist statement, identify a few details, and then a few fact details, and then infer all the other details from those fact details. We don't do that. We can't do that. We can't understand it when neurotypicals do that. Why? Because if you read all these posts on Reddit and Quora that autistic people write and on other internet forums, you will actually see that autistic people are saying that because we are context blind, if we are given these short and plain statements and we do not get this detailed, lengthy writing given to us explaining the whole context, and we don't get it spelled out in detail, we're not getting due process notice. We don't know what's going on. It's not adequate notice to us. And so you have this impasse. You have this impasse in the courts. In the case where I was assigned the Honorable U.S. Magistrate Gary R. Jones, I said that the lawyers in the Florida bar were lacking specific autism training. And one of the defendants in that case, Carl Schwait was a chair or co-chair on the Florida Bar's disciplinary committee in Gainesville, and he was very esteemed. And he came back and said that, well, I was wrong, Mary, I was wrong that he took some specific autism training. And he took it from the University of Florida Autism Card Center. And so I made a public records request on the University of Florida Autism Card Center for those records that showed he took that training. And sure enough, he is one of the only lawyers I have ever met that tried to do the proper thing and went and took the training, but where he erred was, and this big, big error, is that Carl Schwait, in the public records responses, Art Wallen, and the Card Center say that he never took the Temple Grandin Thinking in Pictures component of that special autism training. Temple Grandin and Thinking in Pictures. And why is this so important? Well, there's a very, very significant video on YouTube. It's called Jordan Peterson on Autism. And I'll let Jordan Peterson start to explain it in his words.
Well, what Grandin said was that when she thinks of a church, she has to think of a church she's seen. She can't take the set of all churches and abstract out an iconic representation and use that to represent the set of all churches. She gets fixated on a specific exemplar. And she thinks that one of the problems with autistic people, and they have a very difficult time developing language, by the way, is that they can't abstract out generalized representation across a set of entities. They can't abstract. And then of course, if you can't abstract, then it's also very difficult to manipulate the abstractions. You see very strange behavior with autistic children.
Jordan Peterson on Autism, Essential Truth. It's at YouTube here. And what he talks about in this video is very important because he starts talking near the end of the video about simplifying to the most simple a representation, or you can go out into all the detail and you could change the resolution of basically this iconic representation. And so if you want to put this into the federal rules, the short and plain statement, the neurotypical people are taking this abstracted iconic representation, they're simplifying it. They expect that the person answering this complaint or pleading or motion is going to also be neurotypical so that they can take the same iconic representation and they can bring it out in all its detail and its complexity. And that these are these kinds of labels and categories of all these things across all these different situations. And so, for example, this is why you have shotgun pleadings. They identify autistic people. This is why, for example, in Florida and California, you have these things called vexatious litigant statutes. And they use the diagnostic criteria of autism in Florida to identify someone to name onto a vexatious litigant registry. Why? Because it's a segregated court system. They want to exclude autistic people. And so they're using their diagnostic criteria to name that label that they are frivolous or they are vexatious. And in the 11th Circuit, under the 28 U.S.C. Section 1915 pro se case screening, and this is what my video the first day about the malicious denial of due process is about. And what happens is they have this very standard formula. They look to see if anybody ever called anything you did frivolous before, which autistic people are always labeled frivolous because whatever we have to say is not plausible to a neurotypical, and our autistic common sense is not neurotypical common sense. So there's a big disconnect, and neurotypical people and autistic people are using different languages, and communicating on different levels. One's fact-based, one's inference-based. The inferences are not necessarily what the motivations and intents of the autistic person are. Why? There's a double empathy problem. And so you get these labels, and this is what he's talking about there's a problem. There's a problem. It's a very good video to watch, by the way. And I would recommend anyone interested in the problem of autism in the courts needs to watch this video. And this is a study. It's one of my favorite studies right here. And in this study, how autistic people, autism is a neurodevelopmental condition. That means that our entire neurodiverse neurotype develops differently than a neurotypical person. And it develops from as a fetus in the womb differently. So the courts can club autistic people over the head all they want with rules 8 and 10, shotgun pleadings, and be indistinguishably neurotypical in your language, or else you will not get access to the court. Your case will be dismissed with prejudice. You will not get a remedy, and we suggest you get sanctioned under Rule 11. Sanctioned money. Study used brain organoids. This is living biology to grow brain organoids that show that autistic brains at a physical level are different than neurotypical brains. Okay? So, This study is on Nature here. Autistic brains are different, and we speak a different autistic language. It's immutable. It starts as a fetus. It starts a different trajectory of development from the first trimester. If you grow brain organoids, our brains are physically different. Okay? So when the 11th Circuit is using shotgun pleading rules to target and identify autistic people, and the short and plain statement rules, and what's plausible to a neurotypical, and the common sense of a neurotypical, the brain organoids grown from autistic stem cells show we physically have a different brain. Our language traits and our different autistic brain are immutable. We are born with, and we cannot change to become indistinguishably neurotypical in the way we speak and write and use language. So, or any more than a Black American can turn white. So, this is what the 11th Circuit doesn't understand, but it's deeper than that. Favorite studies in 2022. The initial study Geschwin did found that the gene expression in the frontal and temporal lobes of autistic people did not change during adolescence the way it does in a neurotypical. In other words, the gene expression remains very childlike in an autistic person. Now, this study looks at more of the brain. What's happening is, as a result of the gene expression in autistic brains, they have a gradient toward the visual processing area in the back of the brain. And in essence, this is a Neanderthalized brain. Okay, this is here. Now, autistic brains, or at least some autistic brains, are Neanderthalized. But new study provides strong evidence for the roles of Neanderthal-derived genetic variants in autism susceptibility, suggesting long-term effects of ancient human hybridization on brain organization and function in the autistic brain. And this is based on some of the genes in the Simons and Safari autism gene databases. Neanderthal language differed from modern human language. And so there's a difference in using iconic words and representations. And Neanderthalized brains make semantic clusters of words differently than they do in neurotypical people, in neurotypical brains. So this is not a mutually intelligible language interface between autistic people's immutable language traits and neurotypical language traits. It's not mutually intelligible. They are vastly different brains. Their scientific research at autistic brains are Neanderthalized by brain organoids, physically different. Autistic brains are physically different. Their gene expression is different and has a gradient toward the visual processing center at the rear of the brain, where Neanderthals had the Neanderthal bump on their brain. They had a more elongated and less globular brain. And this is really important because we know that the bar and bench in Florida and within the 11th Circuit is almost 100% homogenously neurotypical. How do we know that? Well, Haley Moss becomes the first autistic lawyer in Florida. This is her video on YouTube. She has never been disciplined by the Florida bar for saying she was. That means that they're implicitly accepting that. There's around 111,000 lawyers in the Florida bar. That makes the Florida bar an almost 100% homogenous neurotypical bar, and because bar membership is generally required for eligibility for the bench, that makes it an almost an 100%, virtually 100% neurotypical bench in the federal courts within the jurisdiction of the 11th Circuit. Again, autistic and neurotypical people speak two different languages. Now, if you're going to make this court system and keep tightening the rules to exclude autistic people based on the immutable traits, language traits of autism, of being autistic, which are Neanderthalized brains, which means that autistic people are very likely speaking a Neanderthalized type language, which is evolutionary and is a totally different language than what neurotypicals are speaking, for all the reasons that I've said here. Even though the words sound alike, it's a different neurological language in the brain, different meanings in the communication, and a missing social component, and no inferences in the autistic language, then the neurotypicals in the courts and the autistic litigants like me, and that's my lived experience, we don't have any mutually intelligible meaning between what my allegations and arguments are saying and what the neurotypical courts are interpreting them as saying. Okay, and that's what Honorable Thomas P. Barber, United States District Court Judge, raised in his order that being autistic likely impacted on the presentation of my allegations and arguments. And the 11th Circuit justices blew it off. And the clerk, they don't want to address it. They just want to keep going on with cases where it's very clear autistic litigants like me are not getting a fundamentally fair and impartial trial. That's just okay. That's fine. Exclude autistic people from the courts completely. Deny them access to the courts. Get rid of them. We don't want them. Don't give them a remedy. And if they keep asking for access to the courts, sanction them. Okay, sanction them. Well, there's a First Amendment. And immutable autistic language traits are free speech. And we use them to petition for a redress of grievances. So there's a substantive right that I have right there to be able to speak my native autistic language in the federal courts and not to have my court access conditioned on my becoming indistinguishably neurotypical, which is something I can't do. I'm not a neurotypical. I can't become one. And in this case, the United States Supreme Court considered another federal rule of civil procedure on mental examinations. And it found that the rule violated the Rules Enabling Act. That's where Congress made a law that says that the federal courts can create their own court rules. And that's how Rules 8 and 10 came about, which is requiring neurotypical language. And then it leads to this Twombly and Iqbal and the plausibility standard and the neurotypical common sense, what's plausible to a neurotypical and the neurotypical common sense. And I raised this to the 11th Circuit that they can't make Rules 8 and 10 and screen the pro se cases on the basis of Rules 8 and 10. To say, label pro se autistic cases as frivolous, and then cite a string of where they've done that before as frivolous. And they can't do it because they're violating the First Amendment substantive right of me as an autistic person with lived autistic experience to speak my different autistic language in accessing the courts and asking for my remedy. Enabling Act that the courts cannot abridge, enlarge, or modify any substantive rights. What the heck do you call being able to use your immutable autistic language difference to communicate your case to a federal court? That's not a substantive right. What if they're conditioning court access on my becoming indistinguishably neurotypical in my language? I can't do it. I'm not neurotypical. I wasn't born neurotypical. Brain organoids show a physical difference in the autistic brain from the neurotypical brain. It's an immutable trait. I have to speak in my autistic language, which is an immutable trait, or the 11th Circuit Court of Appeal is denying me access to the courts. Now, the 11th Circuit, in their shotgun pleading rule, targeting autistic people with immutable autistic language differences, suggested that Rule 11 be used against them, against these kind of people. Well, Rule 11 has been changed. Now it involves an objective standard, not a subjective standard. Okay? Well, what does that mean? That's kind of like a reasonable person standard. Who's a reasonable person? A reasonable neurotypical person? Or a reasonable autistic person? And what's a fact? Is a fact, a literal fact an autistic person gets from the raw sensory data? Or is it a made-up inference-based fact neurotypicals make up from these iconic representations they have of abstractness that might not even be a fact at all? We don't know, but we do know the 11th Circuit says that people who are shotgun pleaders who are autistic, well, they say shotgun pleaders, but it's targeting autistic people, so they should have Rule 11 brought to bear against them. Well, what does that mean? Well, they say, the 11th Circuit has said before in one of my cases, that if I don't obey Rule 8 and 10 and write indistinguishable from a neurotypical, then that's willful and contumacious. So if I have an autistic status, an evolutionary status, an immutable trait, status of an autistic different language, that's willful and contumacious. To access our court, you have to be indistinguishable from a neurotypical. That's what they're really saying. Okay? And so they'll sanction you up to $43,000 under Rule 11. Now, you're an autistic person that's not getting enough sufficient government support to support your autistic needs, your neurodevelopmental needs, and they're going to, by God, sanction you $43,000. Why? They have to deter your autism. They have to deter it. And in the 11th Circuit, and I learned this unfortunate fact from researching it in my case, the 11th Circuit has authorized federal courts to enforce Rule 11 sanctions without any evidentiary hearing and put you directly in prison. No due process hearing. You don't pay the excessive fine that's a clear violation of your 8th Amendment rights. And it's cruel and unusual punishment because the autistic person cannot speak and write indistinguishably from a neurotypical. Now, if you violate because you don't have the money to pay, because you're the typical autistic person with the approximately 86% national unemployment rate, and nobody will hire you, and the costs of autism are, I believe, Harvard scientific study said around 2.6 million over a lifetime that's not being funded, that if it's going to be paid to support the autistic person's needs, it's going to come from the autistic person or their family. If you can't pay those sanctions, you go directly to jail, to prison, in the 11th Circuit Court of Appeals for your immutable, evolutionary trait you cannot change of having a different autistic language. Well, why is that so bad? Because there's a disproportionate number of people who are autistic incarcerated in prisons in the United States that's hugely disproportionate to the number in the general population. Up to 4 times higher than the rate of the general population. In other words, they want to lock all the autistic people up, the neurotypical majority, because they don't want us in their neurotypical society. How is this different than the Australian Aboriginal problem? Now, the United States Supreme Court did consider and rule in a case that's a little bit somewhat analogous, Plyler v. Doe, in 1982. And what was happening there was that there were all these illegal children, migrants, and Texas didn't want to pay for them to get a school education. And so the Supreme Court said, that's not just to be blaming this person, that no child is responsible for his birth, that you're penalizing something the child was born as being, like being autistic is the same thing. And that if Texas is not going to let these kids go to school, and they found, I guess, that education was a fundamental right. Well, access to the courts is a fundamental right. I know I have a fundamental right of access to the courts. That what they're going to do is they're going to create this permanent underclass of people who are socially, economically, intellectually, psychologically deprived, that don't have any opportunities, that it's status-based. In essence, to take a lesson from both Plyler v. Doe and from South Africa, if the 11th Circuit Court of Appeal is going to be allowed to make, with the state of Florida, a segregated court system to segregate autistic people out of access to the courts, punish them and put them in a court-to-prison pipeline and incarcerate them, or tell them they don't get any access to the courts, because if you do, you're going to be thrown out and excluded. You're going to be denied a remedy, and you're going to be punished and fined and sanctioned under Rule 11. And if you don't pay it because you can't, you're going to be incarcerated in a prison with 4 times the general population rate of autistic people to the population. A travesty. What you've got in this country is an autism apartheid. And it's in the 11th Circuit, and they're the ones that's creating it and maintaining it. And they're creating and maintaining no rabbit hole in the middle between the state of Florida's court system and the federal court system in the 11th Circuit. And they want to call that no non-frivolous issue on appeal. They don't want you to take that to the United States Supreme Court and say, United States Supreme Court, I may be nobody. I may be so-called a pro se. I'm just an autistic person. But Supreme Court, I think I have a right of access to the courts. I think I have a right to speak my immutable autistic language. I don't think I can be excluded from a remedy and punished on the basis of my autistic status, which is physical as shown by brain organoids. That starts in the womb. I think I have an inalienable right. It's very, very wrong. And how can you do this to a class of people this way? Autistic people have an autistic identity. We have an autistic culture and community. We have immutable autistic traits. Being autistic is a way of being. How are we not a suspect class? If you like my videos, hit the subscribe button. You'll be notified of my future videos. And thank you for listening.